Welcome, dear viewers. The topic of today's lecture is Henry Maine on stages of development of law. The study of law. The study of law has always evoked considerations of social institutions and societies. Never ever law has been seen without referring to the existing social order of that period. The social institutions, the social processes have broadly affected the patterns in which law developed and was institutionalized. If we go back to history and if we move till the present day, we see that whenever we try to understand law and the legal developments, we always see that the social scenario has large impact on it. The social institutions, the social processes have had a large influence on development of law. The study of law is linked to differential forms of law itself too. Law is not existing in single form. Law has multiplicity. Law has multiple forms. And when we study law, we have to understand or we see or we interpret what are the different forms of law which have been existing in different societies from different times, from different places. There have been different forms of law which existed in different societies and with different conditions and made people stuck to them and abide by them. There have been specific conditions on the basis of which law developed in all societies, or we may say in different societies. For example, legal theory in Europe has been linked to natural laws, moral philosophy, and theology. In Europe, it is believed, it has been theorized that law has developed through moral philosophy, what is right, what is wrong. And this moral philosophy was the product of society itself. And then natural laws. Nature also determines what laws will be. This is what French philosophy, European philosophy says. And theology, believe in religion, believe in monotheism, believe in different forms of religion, different forms of God. All these have had impact on development of law as such or as a theory. Marxian study of law exists in terms of critique of class division of society. When Marx talks of law, when Marx sees law, he sees the law as a part and parcel of theory of or framework of class divisions of society. And also, law has been interpreted as machinery of the ruling class in the hands of ruling class used to oppress the dominated class. Marx says, or Marx has believed, that law has acted as a tool in the hands of rich classes, tools in the hands of dominating classes, the haves classes, the people who had all the ownership of means of production to oppress the other class, to oppress the poorer class. However, Marx saw law functioning in the realm of economic determinism. For him, everything is determined by economy. Economic determinism, that is, forces of production and means of production together determine everything, hence law. So for Marx, law is also a part and parcel of the scenario of economic determinism, where the ruling class owned all the means of production and the dominated class was dependent on the ruling class for their livelihood, in which scenario law worked in favor of the ruling class, of course. Now we'll discuss Henry Maine on law. It's a small topic, very simple topic, but it is very interesting to know how Maine saw law developing or development of stages of law. Henry Maine wrote a book entitled Ancient Law, and he made distinction between static society and progressive society. It resembles Durkheim's organic and mechanical solidarity. He talks of two societies. He says one is static society, which has lesser possibilities, lesser seeds, or lesser chances or priorities for development and progress. Another is progressive society, which has an aim to develop, which has an aim to grow. For him, movement of hitherto societies is a movement from status to contract. This reflects the changes in the social structures and living. Now we see that there has been a shift from status to contract. And status, that is the dominant status of a male, of a head of family, of head of society, to contract means need-based relationship. Now he sees that this reflects the changes in the social structures and living. This resembles Durkheim's repressive law and restorative law theory also. He says that individual is steadily substituted for family as the unit of which civil law takes account for. These changes are brought by non-legal factors since social necessities and opinion are always more or less advanced than law, hence it takes time, but the change does happen. When we talk about static and progressive society of Maine, Henry Maine has seen that the non-legal factors, the social necessities and the social opinions have played a greater role in determining or bringing about these changes. And this role is more dominant than the legal functionaries or law. Maine examined law under three headings. When Henry Maine started understanding law, he saw law or he understood law or he interpreted law through three stages. Number one is legal fiction, number two is equity, and the third heading is legislations. In legal fiction, he sees law as a fiction. When there is nothing established, it is just believed. Things are just believed in. Things are just working on the basis of faith. Things are just working on the basis of social logics, not actual logic, but social logics. So this is legal fiction. Equity. When people were given an equal chance to explore what actually natural laws are, what actually social laws are. And third is legislations. This stage he sees as the stage where law actually started getting codified. This is through these three phases that law came into harmony with society. Now, Henry Maine says that in the very beginning of social order development or society development or societal progress, law was not in harmony with the people. Law was not in harmony with the societies. It took time. And when did society become in harmony or follow the harmonious relation with law is when all these three stages were crossed. That means when legal fiction, equity, and legislation were done through. After these three stages, law actually came in harmony with the society. Stages of development of law by Henry Maine. We'll discuss how Henry Maine explained that law developed. Henry Maine says that the following are the four stages of development of law. Number one, law made by the ruler under divine inspection. Number two, customary law. Number three, knowledge of law in the heads of priests. And number four, codification. These are the four stages which Henry Maine has used to explore and to explain that how did law develop. Number one, law made by the ruler under divine inspection. The command of the king, ruler is the king. So under this stage, Henry Maine says that the law was actually the command of the king. The command of the king is believed to be the command of the god. The king was usually taken or considered as God, or maybe in many cases next to God. So God was not visible. For people, king was the God. For people, the command of the king was believed to be the law. He is believed to be the form of his authority and is obeyed that way only. The king in this stage is believed to be a form of God or a messenger of God or a manager of God who is supposed to be obeyed because God is not there. He is the one who has been sent by him, who has been authorized by him, who has been given powers by him to command the people, and hence this made the people obey the kings as a form of divine inspection. Second stages or second stage of development of law as per Henry Maine is customary law. Priests and the heads of the councils of kingdoms are believed to be repository of laws. In this stage, there's a shift from kings to priest and the council's head. Now, what kings did when they had expanded their kingdoms or when they had large kingdoms, they could not work everywhere. So they had some heads of various councils. Then, and priests were there, churches dwelled, temples in other religions, in other forms, in other terminologies, temples, gurdwaras, or masjids, or whatever, they dwelled, these churches dwelled, and there were heads of those churches, which were called priests. In this stage, in customary law, the term itself tells the custom became dominant. And the custom was believing that priests and the heads of the councils of the kingdoms are the repository of laws, are the knowledge banks of laws, are the actually holders of the information about laws and claim monopoly of knowledge. it was believed that priests and the heads of councils were very knowledgeable about law, and they were actually the monopolizing authority over the law and the knowledge of law. Customs of the community become law since they have power to fetch great obedience. Customary law says that the custom means people keep on doing some things, and those things become habits, and those habits, by the form of tradition, by the passage of time, they become customs. And these customs were the basis of development of law in the second stage of Henry Maine. Number one, in this stage, the dominance is of priests and the heads of the councils of the kingdoms. And number two, customs are the base of development of law, the customary law stage. Third, knowledge of law in the hands of priests. It is made to believe, in this stage, it is made to believe that priests are the only source of those religious values and divine knowledge which are efficient sources of laws, since the law is not yet written and codified. Now, this is a technical thing to be understood. In this stage, there was no law written. There were no laws which were codified. And this was believed that there are some powers, there are some natural rules, there are some things which govern us. There are some divine powers which govern us. And who will convey what are those divine powers? The priests started conveying those divine powers. The priests was started being believed that they are the source of knowledge about the divine powers. And in this particular phase of development of law, as per Henry Maine, it is made to believe that priests are the only source of those religious virtues. When you have to learn, when one has to learn, one has to know what are the religious virtues, what are the laws which govern us, what are the social laws which govern society. In this particular stage, the priests are the dominating personalities. The priests are the dominating sources because the laws are not codified. Whatever they say, that will be believed to be law. Whatever they believe in, whatever they expand out to be a theory, people will start believing in and obeying it. Fourth stage is codification. In this stage, there is a shift from dominance of priests to dominance of scholars and jurists, since law gets written and codified and recorded. Now, in this particular stage, Henry Maine, you can say that this particular stage is the present stage too. It is the most applicable in contemporary times. Henry Maine says the fourth stage of development of law is codification. Now, in this stage, the law starts getting recorded, the law starts getting written, the law starts getting codified. And now there's a shift from the dominance of priests and the heads of councils to jurists, to scholars. Now, who are jurists? Who are expert in understanding, interpreting, or adjudicating on the basis of the written laws. Who are scholars? Who are the source of writing the laws? Who are the source of deciding on what the laws are? So now, in this particular stage, as per Henry Maine, there is a shift from the power or dominance of priests and the heads of the council to the powers and dominance or intelligence acceptance of scholars and jurists, since now the law is written. This makes common man access law sources, and hence the classes which dominate and govern society are of jurists who adjudicate on the basis of existing laws. Now, the common man knows what law is. Earlier, in the customary stage, in the stage of divine inspection of king or command of king, people were not aware of law. People were not aware that what are the laws or what laws are existing and governing societies. So they were dependent on the priest to tell. They were dependent on the king to tell, king to confirm. They were dependent on the heads of the councils of the kingdoms to tell that what laws govern them. But now, in this stage, a common man, the common man knows the law, because law is available in a book form, law is available in a written form, law is available in a codified form. And now he depends or respects or he believes in the power of jurists, because jurists will be the people who will be adjudicating the cases of injustice on the basis of the codified and written law. And common people also depend on and they respect the scholars who interpret law and the functioning of legal and social institutions. For this particular topic, few references have been given. Francis Abraham, Modern Sociological Theory Introduction. Bottomore can be referred to. The title of the book is A Guide to Problems and Literature. Wallace Ruth and Ellison Wolff, Sociological Theory, Expanding the Classical Tradition, Contemporary Pearson's New Delhi publication, and Harlumbus. One of the strongest reference for this particular topic is Harlumbus and Holborn, Sociology, Themes and Perspective. Best of luck. Take care. God bless all. See you very soon.